Well, good afternoon, everyone. My name is Stephanie Hill, and I would like to welcome you to our webinar addressing shelter-in-place order and reopening plan litigation across the country and here in California. A few things to get us started for this webinar today. To eliminate background noise, the audio for all attendees has been muted. You'll be able to hear the presenters, but we won't be able to hear you. So if you have any questions during this webinar, please submit them using the Q&A button located in the black bar on the top or bottom of your screen. Our presenters, Deborah and Meg, will do their best to answer as many questions as possible at the conclusion of the webinar. We are offering MCLE credit, and those certificates will be emailed to you next week. We also emailed a copy of the PowerPoint to everyone earlier this morning. If we experience any delays during the webinar, we will let you know the slide number that is being covered at that time. Today's presenters are Myers-Nave Principal Deborah Fox and of counsel Meg Rosequist. Deborah is the chair of our First Amendment practice and our trial and litigation practice. Meg is a senior attorney in Deborah's group. They have formed a team working on shelter-in-place litigation and have been handling several of these high-impact cases during the last 10 weeks. Deborah and Meg, thank you for being here today. The floor is yours.
Thank you so much, Stephanie. So this is Deborah. I'm going to get us started. Here I am working from home like many of you are doing. I want to thank you for joining us. It has really been a head-spinning last 10 plus weeks as we have been confronting this public health emergency and all the resulting administrative issues, not to mention the very fast-moving litigation that has unfolded. So we're going to try to cover a fair amount of ground today. Let me tell you what we have in mind here. First off, we're going to talk a little bit about the context of this public health emergency. Context is always relevant. It does drive many of the court determinations, and of course, it drives sound decision-making that is happening at a number of levels here. We're going to look at the Supreme Court decision that was just rendered in the South Bay Pentecostal case. We'll also take you through some of the other circuit cases along with the district court cases. It does almost seem like an episode of Law and Order that in 10 short weeks, we already have a decision of the United States Supreme Court here. We're going to do a bit of predicting the future. Talking about some of the issues that we see that may be on the horizon as we make our way through our third month of the pandemic. And then we set aside about 10 minutes for questions here. Also, I want to say, I know I took a quick look at the attendee list, and we have some folks from across this state. There may be information that you have that is really up to date. As everybody knows, this is a very dynamic and fluid environment we're in. So please feel free to liberally use your question and answer or chat if there's something that you think that the whole group could benefit from, and we can also shout that out when we get to the question and answer period. So with that, let's get started here. Context is always relevant, and I want to start a little bit talking about the global pandemic. This is the data points that we pulled up on June 1. What I was struck by when we were working the last 10 weeks is every time I would go to draft a declaration from one of the public health officers, I would draft it on a Saturday morning. By Sunday or Monday, the numbers were significantly changing. And that was really important to tell this story, and the story, of course, is still unfolding. Worldwide, we have 6.1 million cases. We have 373,000 plus deaths. We have in California a total of over 113 and climbing cases and over 4,200 deaths. What we have found and what we know, and the scientific data shows us, that the issues that are the spreaders of this virus are in-person gatherings. I think as well that the information in the next few slides I recommend to you as you are building your record, when it's your staff reports on the declaration of the public emergencies, the amendments of the orders, the building of the record if you are getting potentially litigation from disgruntled residents, business owners, and other affected parties. What is clear in the literature is that there is a high infection rate from folks who are asymptomatic. That ranges from 20 to 50%. So when we see litigation and we see declarations coming in from various business owners saying, I should be able to operate, I have no symptoms, I have no known exposure, I have no known exposure to people who've traveled overseas, we know that those claims really are of no moment because of the asymptomatic nature of this virus. One of the things that really is on my mind and happens close to home here is the issue of super spreaders. At the early part of March, I am down here in Southern California in the county of Los Angeles, one of the hotbeds right now of COVID-19. There, a local mayor from Rancho Palos Verdes had a birthday party over at Trump International Golf Club. That was a super spreader event. The LA County Board of Supervisor members were there. A number of public officials were there. Ultimately, many people got sick and 2 people died. But the literature is quite extensive on this. And Stephanie, can you move us to the next screen? For some reason, my buttons are not working right now. If you could take us to slide 5, please.
Sure.
So this is talking about one of the super spreader events. And again, I bring these for your use in building the record and in declarations that you may be making in any cases you find yourself in. This was a super spreader that happened up in Edmonton, Canada. This was on March 11th to the 14th, 24 of 72 people infected, numbers of doctors, healthcare workers, patients, and other co-workers. These contestants were in a confined, close contact, an indoor environment, sharing indoor space, heavy breathing for extended periods. This is an important point that you may be looking at as we make our way into the next phase of the reopening. We have the clamoring for the reopening of fitness centers and gyms. And of course, those also raise these important issues about health risk, where people visit a gym in enclosed airspace for extended periods of time, many times going to these places several times a week. And if we might move to the next slide. Here are some examples of super spreaders that you've probably been reading about in the literature and on social media and in the headlines of the newspapers. One was an in-person church gathering in Sacramento, over 71 cases. I reported that the congregation was telling the county, just leave us alone, we're wearing masks, we're social distancing. Another that was very much in the press was a choir practice that happened in Washington. 45 of 64 people were diagnosed with COVID-19. 2 have since died. Would also call this out to you when you're thinking about not only the resumption of religious facilities, but also the protests that we're seeing over the last 10 days where people are chanting and also talking and having their voices heard on the streets with the potential spread of COVID-19. Other super spreaders from funerals and birthday parties in Illinois, again, showing a cluster of community transmission. If we might go to the next slide, which is a business meeting that served as a super spreader. I'm sure many of you have heard about this, which was again held in Biogen, 175 executives that had gathered there for a leadership conference. Then they got on planes, trains, and cars, returning home, traveling to other business events all around the state, in fact, all around the world. On March 3rd, Massachusetts was declared the epicenter with 70 of 92 total infections in Massachusetts at that time derived from this Biogen company conference. Moving again to the next slide, number 8. This is another potential issue that's driving the litigation. This is Harmeet Dhillon of Dhillon Law Group. Meet her Twitter account here. This has been an unbelievable resource of finding out what's going on, not only around the state, the country, and localized into my particular cases that Meg and I have been working on. You can see here we have cases that Dhillon Law Group is filing in New Jersey, Wyoming, Orange County, Illinois, Hawaii. And a particular note, many times briefs are posted to the website or linked to this Twitter account. Of note, when we had the Ninth Circuit decision in the South Bay Pentecostal, that came out Friday night. I was talking with Meg and other members of our team on Saturday morning, and I said, well, you know, I really think there's probably going to be some Supreme Court action here. And then I happened to say, let's see what Harmeet's Twitter feed is seeing. And that is the first place I found the reference to the filing of the emergency application to the Supreme Court. So it becomes a very quick way to find out what is going on in the court system. It's also clear, you can read the tea leaves here and see that there are cases being filed and continue to be filed even in the wake of the allowing of religious assemblies of up to 100 people. And a setup to move forward to have some different decisions amongst the circuits for going back to the United States Supreme Court. My time seems to be going a little quickly, so I think I'll go quickly through the California context. If you could take us to slide 10, please, Ms. Stephanie. Here is some of the time factors for when we had the governor declaring the emergency, the executive stay-at-home order, which restricted everyone to stay at home but for critical infrastructure sectors. Then on March 22nd, the California State Public Health Officer designated certain categories of the essential workforce. You may recall there at that particular time, the streaming of religious services was deemed permitted. And then as well, later the state found that indeed the phrase other technology was expanded to include and allow for drive-in theaters. I would note, as many of you probably did as well as you were trying to work your way through the state provisions, that the state never made a clear statement or a direct order that clarified that drive-in theaters were allowed. The first time it actually appeared was in the briefing in the case that Meg will talk about a little later called Gish versus Newsom. So it makes it very difficult to stay current and to make sure that we are able to accurately get the information at all levels here. On May 4th, the governor issued his roadmap, deemed the roadmap to resiliency, a reopening in 4 stages. Moving to the next slide, I know it's one you've probably been studying and looking at, the 4 stages of the reopening of the California economy. What I want to say here is that it's important to notice the distinction of where we started and the analysis and the characterizations that we are now looking to when we looked at the roadmap for reopening. When we started, the whole analysis was essential versus non-essential. And really the focus was on the gathering of people. In the staged reopening, each of these stages is predicated upon public health risks. And so it's critical that we make sure that the staging is based properly on the characterization and the categorization appropriately of those health risks. And so they are not seen as arbitrary. And so I do think that we're going to have more and more litigation about those issues as we are in this phase reopening. It's illustrated very well by in-person religious services, and if we might move to slide 13. when I look at slides 13, I realize why I'm a little tired now as we start off June. It was just a head-spinning 10 to 12 days here in May. This slide really captures the dynamic nature of what happened. First, on May 19th, the DOJ sends a letter to Governor Newsom urging the reopening of religious institutions. That's on Tuesday. On Thursday, a group of 1,500 pastors write to Governor Newsom saying they're going to hold services on Pentecost, declaring themselves essential and exempting themselves from the stay-at-home order. Then we have on Friday, May 22nd, I believe it was about at 9:30 p.m. because I think I had to sneak into the bathroom actually because my phone was blowing up to try to find out what was happening, to find the decision of the Ninth Circuit ruling that evening. That following Saturday morning, the CDC revises its guidelines on worship services. And then I would also note that that Saturday morning, also, Dhillon Law Group and other coalition councils talk about an emergency application to the Supreme Court. But that holiday weekend just continued to give more in this area. On Memorial Day, Governor Newsom issues his new regulations for religious institutions. Those are the regulations where he allows for 25% occupancy or 100% max. This is just prior to Pentecost, which is set for Sunday, May 31st. And we get then a ruling in the Supreme Court case in South Bay United Pentecostal versus the County of San Diego on Friday, May 29th. It seems like all the big things happen in this case on Friday, so luckily we're sheltering at home, so we have time to address all of this. Let's move for a quick discussion. First, I have to thank Meg for letting me talk about South Bay Pentecostal at the Supreme Court. We had to arm wrestle virtually about this. This case was decided on Friday, May 29th. The majority offers a scant 2 pages. It's important to note the procedural posture of this case. It's an emergency application for injunctive relief, and it is coming out of San Diego, a church in Chula Vista, a mega church. They exceed the 100-person threshold. I think it is critically important to note that it was clear that Governor Newsom wanted those new regulations to allow for the provision of in-person religious services before the Supreme Court took this issue up. There was another emergency application from Chicago, Illinois area that was also pending to the U.S. Supreme Court. In any event, in a 5-4 decision, the court rejected the church's emergency application. It did not block the enforcement on the restriction. The court talks very much about the fact of the high standard that was at play to be able to get such an injunction. And the court did consider, of course, the new numerical restrictions that had been adopted by the governor. The court noted in the concurrence written by Judge Roberts that the California guidelines appear consistent with the free exercise clause. If we could go to slide 15, please. Catching up on our slides here, and moving on, if you would, Stephanie, to slide 16. Here the court said that the restrictions in place were valid because they were comparable to similar secular gatherings. And the majority was comparing the comparison to lectures, concerts, movie theaters, spectator sports. And the key issue in whether or not these provisions are going to survive is what the comparative denominator is. is the appropriate comparison to these particular noted items, or is it more appropriate to compare them to grocery stores, banks, Walmarts, Costco's, etc.? The majority said the appropriate characterization was these venues where people come together for a communal purpose. And it's qualitatively different if you're going to a theater performance or if you're going to church to gather together, as opposed when you go to a Costco or a Vaughn's. There could be the same number of people at the those particular entities, but they are not gathering in the same manner, nor are they staying together for the same long period of time. The court also noted there that the elected officials should be given latitude with decisions that are fraught with uncertainties with medical and scientific data. Moving to the next slide, which is Judge Kavanaugh's dissent. He saw the comparative of the secular versus non-secular activities to not be appropriate as reviewed by the majority. He would have found that this was indeed improper. I would also raise an issue for us all to think about of whether or not the state would be in a better position if we indeed had an imposition of any numerical numbers on Walmart's and Costco's and Vaughn's in comparison to the numerical limitations that we have on religious facilities. If I move on to the next slide, which is slide 18, this is just a summary of what the finding was by the Supreme Court. I would say that as well, it was very telling in the recitation of the Lukumi case. I know Meg's going to talk about that, and since I'm running over on my time, I'm going to defer that to her and pass the virtual mouse over to Meg to take us through some of the other cases through the various circuits, not the least of which was the Ninth Circuit's ruling on South Bay Pentecostal. Meg, take it away.
All right, thank you, Deborah, and I'm happy to take on from there. This has been, as Deborah said, a very interesting and intense time for many reasons, but work-wise, dealing with these issues has been very interesting and very of the moment. Before I move from this slide, just to follow up on what Deborah is saying, one of the critical aspects that seems to be determinative of how the courts rule on whether these stay-at-home orders, reopening plans, and restrictions on gatherings pass constitutional muster is what they look at as the comparable secular activity. So I'm just going to highlight that because we'll see that that comes to play in a lot of these cases. So the South Bay Pentecostal case actually first came before the district court, as Deborah said, in San Diego before Judge Bichat, and then where she denied the TRO, and then went up to the Ninth Circuit, and then of course went up to the Supreme Court, as Deborah just discussed. But as the Supreme Court's decision was a decision on an interlocutory order, and it was that close 5-4 decision, and Justice Roberts also left himself some wiggle room. We're not going to see the litigation from these religious organizations going away. So it is still quite interesting and pertinent to know how the Ninth Circuit, the other circuits, and then the district courts within California are looking at this issue. The Ninth Circuit majority opinion was a short three-page opinion, and they don't tip their hand that much as to how they're going to analyze these issues in more detail. They do reject the application to stay the limitations on in-person religious services, and that ruling came out on Friday, May 22nd. And it's interesting to note that that ruling came out, and also the lower court's ruling rejecting the TRO application came out at a time when the restrictions on in-person gatherings, religious gatherings, were still in place. The roadmap to reopening had started. Some of the stage 2 activities, such as certain retail activities, had been allowed to start, but the religious gatherings had not at that point been reopened on this limited capacity where you have 100 or fewer. That didn't happen until a couple of days after the Ninth Circuit's ruling. So that's interesting to note, because by the time the Supreme Court ruled on it, they were allowed to do the in-person religious gatherings if it was no more than 100 people. But the Ninth Circuit upheld on, again, it was an interlocutory order, but found that the stay-at-home orders and the phased reopening under the roadmap likely passed constitutional muster, even when the religious gatherings weren't yet being opened. So the Ninth Circuit, a lot of the district courts in California and also across the nation had been upholding these stay-at-home orders based on a Supreme Court case, Jacobson, from over 100 years ago, that had to do with the emergency powers. And, you know, it's kind of a once-in-a-century type of time where these emergency powers would be justified, such as now when we have this pandemic. But interestingly, the Ninth Circuit decision doesn't touch upon Jacobson. It doesn't disapprove of it or approve of it. There was a vigorous 19-page dissent by one of the judges in the Ninth Circuit, and that dissent calls out that Jacobson, that judge believes, is not the correct rubric. So it will be interesting to see whether the Jacobson, as the Ninth Circuit considers some of these cases that are percolating up to it, and it issued some more detailed orders, whether the Jacobson rubric will apply, or whether it'll be traditional constitutional analysis. At the end of the day, I don't think that's going to be the determinative factor, because whether you're under Jacobson or the more traditional constitutional analysis, I think the determinative factors for the courts are going to be what they see as the comparable activity at play, and whether you have, as Deborah discussed earlier, created your record to show that there's a scientific basis for the distinctions and limitations that are being made. A couple other circuits have looked at this issue as well. Deborah briefly touched upon the Seventh Circuit decision in Aleem that also went up to the Supreme Court. The Seventh Circuit was in line with how the Ninth Circuit had looked at this decision as well. At issue in Aleem was restrictions by the governor of Illinois on in-person gatherings, including worship services. There was a 10-person limit. So by the time that this issue was before the Supreme Court, the governor had repealed or that limitation, finding that it wasn't needed anymore, and the state had put into place limitations similar to those that have been adopted by California, where you have the 25% cap on maximum occupancy or a 100-person attendee limit. But unlike here in California, those guidelines are voluntary. So the Supreme Court found that this issue was moot and didn't rule on the restrictions that were at issue in Aleem. The Sixth Circuit has actually looked at the issue as well and found, contrary to the Ninth and the Seventh Circuit, that restrictions on in-person gatherings likely did violate the First Amendment's free exercise clause. And this case highlights that, again, the driving force here and the kind of determinative factors often how the courts look at what is the comparable activity. So there were exceptions to the stay-at-home order at issue in Kentucky, just as there have been in all the states and counties, whether those exceptions are for essential services or as you have roadmaps for reopening, whether they're weighing up risk and allowing certain activities to restart before others. But there, the court found that these exceptions meant the law was not one of general applicability, and that religion was not being treated equally and fairly as to comparable activities. And the Sixth Circuit there found that comparable activities were were active, like law firms were allowed to still operate, laundromats, liquor stores, gun shops, airlines. So these are more like the retail type activities that the churches have been calling out here in California that they're akin to, and they're not the type of activities that the Ninth Circuit, Sixth Circuit, and also the Supreme Court now has looked at as the comparable activities, which are more these communal gatherings that you have for theaters and concerts. What will be interesting is as the plaintiffs pivot in these cases and bring new cases, they will be trying to make more of a factual record to make the in-person religious gatherings seem akin to some of these other activities. It would appear that the Sixth Circuit's decision in this Roberts case would not be in line with the Supreme Court's ruling in South Bay Pentecostal, but the government did not appeal this ruling, so it didn't reach the Supreme Court to get a ruling on that issue. So what are some of the open questions here? It will be interesting to see how the courts rule on the reopening plans, because we know that we're going to continue to get challenges from not just the religious organizations, but from the different businesses that are going to make claims and allegations that they're being treated unfairly if certain businesses or activities are allowed to reopen before other activity. And I've highlighted this because and I'll say it again, I think one of the key issues is going to be how the courts look at the comparable activity as far as both with secular activity and the religious activity, but also as between different types of secular activity. And then also, it's going to be interesting, this might be more on a kind of analytical level of whether the Jacobson case is going to have any impact moving forward, because neither the Supreme Court nor the Ninth Circuit called that case out, while the lower district court cases have relied heavily on that case. So just to give a quick overview of Jacobson, as I said, Supreme Court case from over 100 years ago. And in that case, the court noted that the review of temporary measures taken during an emergency does not trigger traditional constitutional analysis, but instead looks at whether the actions have a real or substantial relation to the crisis at issue. And here, the courts have had no problem finding that the stay-at-home orders and the other limitations have a real connection and nexus to the goal of limiting the spread of COVID-19. And then the second part of the test is it looks at whether the measures are all beyond all question a plain and palpable invasion of a clearly protected right. The courts have noted that that's not a well-developed standard, and even the courts that are relying on the kind of emergency powers under Jacobson, when they get to this second prong, they do revert to traditional constitutional analysis to measure up whether the restrictions on the religious gatherings pass muster. So I think even if the Ninth Circuit and the Supreme Court don't directly rely on Jacobson, I think under the traditional constitutional analysis, the courts will get to the same place as far as how they're weighing up the crisis that's being dealt with and the restrictions on the rights. The traditional constitutional analysis, the courts look to the Church of Lukumi case from the Supreme Court. And in Church of Lukumi, what was at issue were neutral on their face, neutral regulations restricting animal sacrifice. But the court dug deeper and said, even though this is a neutral law of general application, what's really going on is that these restrictions were enacted to target a particular religion and religious practice that had to do with animal sacrifice. So in Lukumi, the regulation did not survive constitutional muster. The courts, the lower courts here in California, the district courts, have looked at Lukumi and found that the stay-at-home orders and the reopening plans are in fact orders and laws of general application. They're neutral, and they're not targeting religion in particular. They might have an incidental effect on a religious practice, but they are geared at gatherings in general, not a religious practice in particular. The Abiding Place Ministries case is also before Judge Bashad. As I mentioned earlier, the South Bay Pentecostal also was before Judge Bashad. This case, Judge Bashad denied the request for a TRO, and then just yesterday there was a hearing on the motion for preliminary injunction. So this is not one of the cases that Deborah and I are handling, but it's one that we're quite interested in. So I called in to listen to the hearing yesterday. Judge Bashad did not, she took it under submission, so she hasn't issued her ruling. She had 3 questions for the parties to consider and to address in their oral argument before her. And those were, 1, she wanted to know what are the current state rules, because as she noted, it's a moving target, and she wanted to be sure that she knew exactly what the rules are as of now. And both sides agreed that there was the 25% cap or 100 attendee limitation, that's what is the pertinent restrictions right now. And then second, she wanted to know what about the current orders the plaintiffs were actually challenging. So the plaintiffs, when plaintiffs' counsel started out with the oral argument, they focused on the 13 pages of additional limitations and guidance that go along with the 100-person cap. But it became clear later in the argument that they are continuing to challenge the initial stay-at-home order as well. Then her third question, which I think is quite telling, was she wanted to know why the Supreme Court's decision in the South Bay Pentecostal case was not dispositive here. So, of course, the plaintiffs made their case as to why it was not, and the state and county made their case as to why it should be dispositive here. And she quoted, the court herself quoted quite extensively from Roberts' concurring decision, which also was very in line from her initial decision in the South Bay Pentecostal when she denied the TRO. So it'll be interesting to get the court's ruling in this case as well.
And Meg, can I just jump in and just add another information to everyone to share that? And that is, I think it's important to know that anyone can call the clerk and get the dial-in number so you can listen into these hearings. Most of the federal courts are treating these hearings as they would be an open courtroom, so you should be able to come. I did think it was also interesting that in the first hearing we had in Gish versus Newsom, a member of the DOJ actually was listening in, and as many of you know, the DOJ has been sending letters of interest in intervening in some cases outside of California. Today, they have not intervened in any case in California. And I'm also wondering, Meg, if you might comment about whether you see the new regs being subject to some additional constitutional claims, for example, of precluding the laying on of hands, or how you could touch or not touch the sacrament during religious services. I'm wondering if you think that we might have some arguments for entanglement of church and state, and any thoughts you might have on those issues.
Actually, I'm glad you brought that up. So that's really interesting points, and actually those are arguments that were made by plaintiff's counsel in the Abiding Place Ministries case that I listened in on yesterday. So plaintiff's counsel made exactly those arguments, that there was an excessive entanglement here because the 13 pages of guidance on how these religious in-person gatherings can resume are very detailed, and he called out a couple of examples. So he said the wearing of face masks, that for the congregation at issue in Abiding Place Ministries, they believe that they cannot pray with anything with face coverings on, so that goes against their tenements. And then he also said that the guidelines had to do with whether you could sing or not, and where ministers should stand in the churches, and so made that exact argument, the excessive entanglement. The court actually asked whether those 13 pages of guidelines were mandatory or were suggestions, and plaintiff's counsel said they believed they were mandatory. The state's counsel hedged on that point, saying that the churches had discretion in how they adopt these guidelines to ensure that they're limiting as much as possible the spread of COVID-19. And so when the court asked whether they were mandatory, the counsel did not say yes or no, but simply repeated that there was this discretionary aspect. So that's kind of an interesting point as well. I do think that we're going to see that more and more in challenges, and also if the plaintiffs start amending their complaints, for instance, in this Gish and cross-culture case that Deborah and I are handling. Right now, the way those cases are positioned is that they are just challenging the initial stay-at-home orders. Their TRO applications were denied, and in the Gish matter, their emergency application for an injunction pending appeal to the Ninth Circuit was also denied. Cross-culture dropped their emergency appeal to the Ninth Circuit once the governor came out with the guidelines that allow in-person services up to 100 attendees. So right now these complaints have not been amended, but I think they may be amended and come up with the arguments that Deborah has just articulated. So returning to the Gish and cross-culture matters, in these cases, both the judges, Judge Bernal out of the Eastern District and Judge Mendez, Judge Mendez, both found that the restrictions on the in-person gatherings were permissible under Jacobson, and then also under traditional constitutional analysis. They both looked at the issue of the essential services exceptions, because at that time, that's what the plaintiffs were focusing on, that they should be treated the same as essential services. And both courts found that those were not the comparable activity at issue, that picking up groceries and getting medicine is not analogous to the in-person gatherings, but rather activities such as schools, restaurants, sporting events, and concerts. So I'll just kind of loop back and note this is another reason that the state probably wanted to make sure that they got their guidelines out for the in-person religious services before the issue was before the Supreme Court, because they were already starting to allow in-person restaurant activity, which a lot of the courts had been looking at as comparable to the in-person religious activities. Where are we headed? Well, we've kind of touched upon that, and Deborah's question certainly highlighted some of the issues that we'll be dealing with moving forward as far as the religious challenges from religious organizations go. But we'll also have challenges, and have had challenges, from business, the business community as well. One of the probably most well-known is the litigation brought by Tesla against Alameda County. And in that instance, Tesla wanted to resume their manufacturing activities at their Fremont plant. The governor had allowed manufacturing to resume as of May 8th, but Alameda County was still restricting manufacturing. So the counties cannot be less restrictive than what the state allows, but they can be more restrictive. So that's what was happening here, and that's why the state was actually not part of this lawsuit. So a lot of people viewed this as Tesla's leveraged effort for the plant to reopen. I've also heard it described as a high-stakes poker game. So it was probably both, and it eventually the parties did come to an agreement. They worked out what the safety guidelines would be, and Alameda County allowed Tesla to resume business at their factory on May 18th. And the case has since been dismissed. Another case that Deborah and I are involved in that was not brought by a religious organization, but by a business entity, was Best Supplement Guide, and in this instance, it was a gym owner challenging the stay-at-home orders and the phased reopening, complaining that his 500-person plus gym should be allowed to reopen earlier in the phased reopening plan. And in this case, I think what was particularly interesting is that the court paid close attention to the detailed declaration from the public health officer of the county of San Joaquin, and Deborah worked quite closely with Dr. Park to put that together and put in Superspreader events and really highlighting the need for this type of phased reopening, and not that just because you're allowing certain business activity to open doesn't mean that everything has to be opened all at once, and that in fact you need to do this phased reopening. And this was in part because the gym owner was making claims that because he didn't have COVID-19 and others didn't have COVID-19 or weren't showing symptoms of it, and there'd been a flattening of the curve, that there was no longer any justification for the gym closure. So it was important to really have that factual record, and the court did make reference to it in its order. The court also noted that there was no First Amendment protected activity at issue.
Hey, Meg, can I just add one thing to the best supplements, and that is that yesterday the plaintiffs amended, and they amended to contend and listed the whole litany of protests that have gone on across the state, from Pasadena to San Francisco, LA, with embedded pictures in the amended complaint, claiming that the protest activities were not abiding by the governor's regulations of a limit of no more than 100, and said that this was a sign of unequal treatment, a violation of equal protection, and disparate treatment of the gym. I suppose if they had some First Amendment activity that they've ever identified, that might be some of concern in the First Amendment context, but perhaps there might be another plaintiff who's going to make those arguments within a more viable First Amendment context. So I just wanted to offer that up to the folks of a real life update here.
Yeah, I think that's a really interesting point. I think that, and I'm going to actually skip to the next slide on that point, that deals with the protest and how the protest activity may impact litigation on the COVID-19 regulations going forward. Just to step back for a moment, again, before Judge Mendez, there was another case challenging the stay-at-home orders, and this case was brought by two plaintiffs, one of whom was a gun shop owner and wanted to protest in front of the state capitol as to the delays in the background checks. And the other plaintiff in this case was a candidate for the U.S. Congress and wanted to hold a rally. So in order to do that, you need a permit from the CHP. Those permits were denied based on the stay-at-home order, and Judge Mendez denied the request for a TRO. Now, as Deborah mentioned, now the rules for the in-person protests have been loosened in the same way that they have for religious gatherings. You can have 25% of an area's maximum capacity or up to 100 people. And as we know, in the protests and demonstrations that have been happening throughout the state and across the country, but I guess in particular for what we're talking about here with what's happening in the states and the counties and with the rules at play, they have been not in compliance with this. The state and the counties, for the most part, have relied on self-regulation by people and self-enforcement, and when people are not complying, most often it has been on a kind of an educational basis that police officers and sheriffs have gone out. And I know, Deborah, you and I have talked with different clients about whether the stay-at-home orders are a basis for regulating the demonstrations and protests that have happened. So far, the clients that we've talked with have not wanted to go that route, understandably, because of a kind of arguments about uneven enforcement, that it was just being targeted towards the demonstrations and protesters, and so has been handling those issues in different ways. And then, as Deborah mentioned, it is interesting now in this case that we have with the gym owner that plaintiff is now trying to use it as leverage in their case. I think, as Deborah mentioned, I don't think it's going to help in that case much, because there's no First Amendment protected activity as far as the gym goes, but it may be something, and probably is something, that we'll see in cases going forward. And Deborah, with that, I think I will pass the baton to you for some kind of final issues to consider.
Okay, great. Thank you, Meg. I wanted just to add one more comment about Givens versus Newsom, and that is that I think that the recent protests in the wake of the murder of George Floyd are spontaneous permits, protests, separate and distinct from the issues that were at play in Givens. So I'm not sure that Givens would give much support for restricting any sort of protest activity based on Santa Monica Food Not Bombs versus City of Santa Monica. But if there couldn't be a more complicated congruence of constitutional issues, I think it might be coming in that next case. On issues to consider, I was trying to see what I saw and what we talked about as a team on the horizon. And so the first one is enforcement. I mean, from the beginning, we knew that was going to be a big issue. One is the state's ability to compel compliance. We saw that with the beaches in Orange County. We saw that as well most recently in the funding disputes and the state flexing its virtual muscle. I think many of us are familiar with the letter from Cal OES sent to Tulare County, talking about that the county's actions could threaten the county's eligibility for disaster funding, as well talking about the budget proposal of the governor that had an allocation of $1.3 billion for the counties for COVID-19 recovery and $450 million for the cities for COVID recovery. I think we're waiting to see how those unfold. I'm certainly hopeful that perhaps some of our Tulare County colleagues, if they're able to, attending today, maybe they could do a shout out and let us know what has happened and if there's been a resolution. It seemed to me that most folks were finding a way to collaborate to get to yes here. Certainly with the phased reopening, perhaps some of those issues are going to pass by the wayside. I was thinking about, though, other plaintiffs waiting in the wings. One thing we didn't touch upon, but we have had a number of amicus requests, and we have had a number of letters in these scenarios from the Center for the Separation of Church and State. And if they are probably waiting in the wings to be a plaintiff here. I could also see if the state and county officials pull back from compliance or these public health orders, whether or not we'll see some class actions brought on behalf of disability advocates or other nonprofits. I also got a question, I think, before the program began about whether or not we might see some actions against public entities from super spreaders if it happens at a public meeting, a board meeting, a council meeting. While there are, of course, various immunities that are at play at the government code, discretionary immunities that go from emergency situations, I think that, again, will be a very interesting gray area. What if a local board decides, despite the health officers' warnings, to go ahead and have a public assembly? Will that lead to a different dynamic in the court of the ability to get out on a immunity claim? I'm anticipating as well that we're going to see some disputes between the public health officer and perhaps the board of supervisors, who has the power to declare and to reopen. Those things, I think, will be facing us in the future. I think we probably now should open it up to some questions. I wanted to thank everyone for joining us here this afternoon. And we'll click on and see if we have any questions, or I don't know, Steph, if you are operating the questions for us. And since I'm not hearing Stephanie, I found a question. It says, question submitted, according to our current county health officer's order, as a public agency, we can require the public to wear a face covering when doing business with the city. Can we refuse service if a member of the public refuses to wear a face covering? If yes, thoughts on addressing the disgruntled residents' response? Meg, do you want to tackle that one, or you want me to wade in?
Well, it'd probably be good to hear from both of us. That's interesting, because certainly private businesses can refuse to give service to those not wearing face masks because of the health risks. And here you have to weigh up the government's ability to do that while providing public services. Looking at it first blush, I would think that is something that you could do, that you could require, because of the health and safety issues, you could require somebody to temporarily wear a face mask while they're in public to get these government services. What are your thoughts, Deborah?
I think I would go in that same direction, Meg. I think if the county's public health order is allowing and requiring the wearing of face masks, that you could do so. I would suggest that you have face masks available. And, you know, of course, there's alternatives, you know, to face masks of covering the face so that they can be provided services. So hopefully that would eliminate a lot of the disgruntled nature, although we have noted the politicizing of every issue, including face masks. So perhaps that was one we should have also put on the horizon of things to come.
Yeah, and I think another interesting issue that may arise is if there is a big spike in not just COVID-19 cases, but a big spike of those being hospitalized, and certainly a big spike in deaths. And you see a concern that hospitals are going to have more incoming patients than they have capacity for. What it would look like if the state and the county start pulling back and making restrictions tighter again. I think that's going to be difficult to rein things back in.
There's a new question. Do you think there are valid taking arguments that may be raised by businesses forced to close during shelter in place? I hope not. We have, in that bus supplements case, there are some takings claims that are raised there, that it's a regulatory taking. I don't think that those will meet the definition for takings. Meg, do you recall, aren't there some taking cases that were from around the country that rejected a claim for a takings challenge?
Yeah, and of course, we are developing that argument for the best supplement as well. But some of the issues are that it's temporary. It's not this, permanent closure of the business, and that also, at least for us in our case, it wasn't a foreclosure of all business activity. And in fact, some business activity was continuing, whether it was classes via Zoom or people picking up herbal supplements and such from the gym as a curbside pickup. So, and the few cases, there haven't been a lot of cases across the country that have dealt with this takings issue, partly because more of the cases have been brought by religious organizations, and there have been fewer cases by business entities, but I think there's going to be an uptick in those. But the few cases that have looked at the takings issue, I don't know of any in California, any court ruling on in California, but the few in other jurisdictions, the takings arguments have not won the day.
So maybe I can get one more in, and then I know we're probably at our time. There was a question about, do you think the mootness argument will hold up with a claim that the shelter-in-place are capable of being repeated? I don't think that the mootness argument of saying that the issues are moot will succeed. I do think that the courts are going to be reluctant to knock cases out on a procedural basis like that. And because of the nature of the prediction of the second wave, and now with all the protests and the issues that we think we may find ourselves in a surge right now, I don't think mootness will be a solid defense for shelter-in-place issues. And with that, Stephanie, do you want to send us on out here?
Sure. Thank you, Deborah and Meg, for your presentation today. We had a lot of great comments come in, and we thank everyone for attending and their questions. Following the webinar, we will be working on posting the recording to our website, so you can find it there within the next week, and we will circulate MCLE credits to those in need. Thank you, everyone. Thank you guys again for presenting, and we wish you the best of your week.
Thanks. Be well, everyone. Stay safe.
Thank you, everyone.